Happy Friday. I'm going to give everybody a minute to get connected. Still a lot of people entering from the waiting room and getting their video and sound connected. We are so glad that you have joined us today. My name is Anissa Mitchell. I'm with PMD Alliance. I'm very happy to have you for this very important discussion today. This is actually the second part in our two-part series, our legacy series. This one is focusing on estate planning essentials and planning for your future. Now, I know this is a difficult conversation sometimes, but a very, very important conversation. And everybody's situation is different. So I don't know that we can necessarily address a specific situation, but we have a guest speaker today who's an elder law attorney, and she's going to explain some general information, some documents that can help you in your planning. So before we get started and I do her introduction, I just want to invite you to open up your chat box. And I welcome you to ask questions throughout the conversation today. And so we will try to go through those as we go through the conversation. And I would love also to get a shout out. So Judy did already. Thank you, Judy, for giving us a shout out from Sun City, Arizona. So let us know where you're joining from so that we can kind of know what states that might be represented today. We have with us attorney Phoebe Harris, who is a practicing attorney. She works full-time in the Green Valley, Arizona area, and she is an attorney that focuses on elder law, estate planning, and that is what we're going to be discussing today. And that actually encompasses more than just a will. And she's going to be explaining what some of these documents are, the differences of what they are, how they can serve a purpose. And while again, some states are different than others, we're going to try to cover as much that's as general to all the states as we can. And so I want to pass this over to Phoebe, and she'll give us a little more of her background, and then she's going to just start us in. And again, ask your questions as we go, and we're very excited to have this conversation. Thanks, Phoebe, for joining us today.
Thank you so very much. I'm so very honored to be here. I have spoken to our local Green Valley, Arizona Parkinson's group for many years, and they're a great bunch of people, and they've asked me back a number of times. I was truly honored to be asked by the PMD Alliance to speak today, and I did watch the estate planning attorney from last year from Florida, and also the gentleman last week with the 5 wishes. So I'm hoping to bring a little more information and detail and answer any and all questions you might have. Most importantly, in any of my speaking events, I do like to be interrupted. So if you do have a specific question or you need more clarity, as to what I'm saying, or if something's not making sense, be sure to type something in the chat, and Anissa will interrupt me and ask your question. Of course, if you have a very specific question, very personal question, just understand that there are numerous people on this meeting, and of course, I'm not offering personalized legal advice, just legal advice in general. But I will try to answer your questions to the best of my ability, no matter what state you're in, whether it be Arizona or another state. So I practice law down here in Southern Arizona, Tucson and Green Valley. I was born and raised in Tucson, and I went to the University of Arizona for my undergraduate degree. And then I got my law degree from Valparaiso, Indiana. So I married my husband at the beginning of my 3rd year. He was in the U.S. Army Ranger Battalion stationed out of Fort Lewis, Washington. So I moved to Washington State after law school, and I was corporate in-house counsel for a biometrics corporation. And after he got out of the Army, he got on with the Border Patrol, and the very first station they offered him was Tucson. So I came home. Which was great. I practiced law with my father, Walter Henderson. And when my husband was offered the Tucson station from the Border Patrol, I called my dad and I said I needed a job. And it worked out awesome. He was actually looking for an associate at that time. And he said, you know, I might have an opening down in our Green Valley office. So here I am. I joined the firm in September of 2008. I was licensed in the state of Washington and became licensed here in the state of Arizona. When was that? 09, early 09. So we handle all estate planning, wills, trusts, powers of attorney, and I also handle all the litigation for the firm. So I do all the wills and the trust contests, the guardianships, conservatorships, and any other litigation needs our clients have. So whenever I do any sort of public speaking event, I always like to start out with the basic understanding of the basic estate planning documents. So estate planning documents, they come in two forms. They're those documents that are valid during your lifetime, and then there are those documents that are valid after your death. So I like to kind of take it in that direction of starting with the lifetime documents. So I'm sure we've all heard of them. We all know of them. The powers of attorney and living wills. Powers of attorney, the state of Arizona allows you to separate them out. So you can have a financial power of attorney, wherein you name someone to handle all of your financial affairs for you during your lifetime, and a healthcare power of attorney. So naming someone to handle all of your healthcare, medical. Arizona even takes it a step further to a mental healthcare power of attorney and behavioral health. So Arizona is also unique in the fact that Arizona allows you to combine all powers into one document. So it's a durable, general, combined power of attorney. So if you trust the same person to handle your finances as you do to handle your healthcare, you can have one power of attorney, just one document. It grants them all powers. So power over the person, property, financial, medical, and mental health. Arizona is also unique. I can only speak to Arizona, is unique in the fact that you can name your agents, that is the person that serves underneath your power of attorney, in the alternative capacity. So in the or, if you trust more than one person, you can name, you know, person A or person B. Those agents named in the alternative do not have to act together. They do not have to be together. And either one, or however many you want to name in the or, can act independent of one another. So it's a great, great feature of Arizona law. For example, my power of attorney, I name my husband first, of course, and then after him, I name my mother or my father or my brother. I don't care which one of the three get here, just somebody get here. I trust all three equally. And if my husband were unable to serve, I would want any one of the three to take over. It's also a great feature if the people you're naming don't live in the same state that you live. So we have clients that have a child in California and another child in Maine. Well, odds on the child in California would be here first if any emergency situation came about. But what if the child in California is on a cruise or overseas vacationing? If you trust them equally, it's always good to have another person named that could possibly get here first. So
Phoebe, I have a question for you.
Yes.
Are there other names for that agent in other states?
Yes.
And
Okay.
can you maybe say what some of those names could potentially be?
Absolutely. So powers of attorney, sometimes called a healthcare proxy, sometimes just called a general POA. In Arizona, they're called an agent. Other states, they're called an attorney in fact. Sometimes they're also even called just a representative, like a legal appointed person, a nominee, a fiduciary, something of that nature. Another thing, and this kind of segues as well. So what happens if you don't have a power of attorney? Well, as we all know, if you do not properly prepare, the laws of your state have essentially already made these legal decisions for you. So if you do not have a power of attorney, let's say a healthcare power of attorney, or you have not nominated a healthcare proxy, some states, Arizona appoints what is known as a guardian. So the court would appoint a court-appointed guardian to be in charge of your person and your healthcare decisions. This is a public proceeding. It's quite expensive. It's all public record. There are annual filings, there are annual reports, and of course, there are annual fees. So if you do not have a healthcare power of attorney, a court could appoint a guardian to serve for your healthcare needs during your lifetime. Same thing, financial. So you don't have a financial power of attorney. Well, the law is going to take care of you anyways, and they will appoint what is known as a conservator. I do know, I just had this come across our practice, the state of California, for example, they only appoint conservators, and they'll have a conservatorship over the person. So that would be your healthcare, your personal needs and desires, and then a conservator over the estate. In other words, a conservator over your property, your bank accounts, etc. So California does not appoint a guardian and conservator. California just appoints a conservator over either the person or the estate or both. To eliminate the courts, to eliminate any ambiguity, any public disclosure of your private information, to save a lot of hassle for your family members, do a power of attorney. Guardianships and conservatorships, those legal proceedings can last, well, they would last for the duration of your lifetime. Again, there's annual filings. In the state of Arizona, there's a court-appointed investigator. The alleged incapacitated person is also appointed a court-appointed attorney. And everybody is represented by legal counsel. So to say that it is cheaper to properly have your powers of attorney in place than to have a court adjudicate a guardian and conservator is an understatement. The filing fees, for example, in Arizona, just to open a guardianship and conservatorship is $204, plus $31.50 for the certified letters. The court-appointed investigator, the court-appointed medical examiner, the court-appointed attorney. We've seen bills as high as $5,000 all the way up to $20,000. So to spend a few $100 on a power of attorney to eliminate the courts, eliminate public disclosure, and eliminate all of the hoops that the court has to go through is definitely worth it, and something we recommend to everyone. I actually personally recommend that anyone over the age of 18 have a power of attorney. Once an individual becomes a legal adult, any sort of blood relationship, marital relationship, familial relationship is no longer valid. So if you have an 18-year-old child and they go to the hospital, the doctors legally cannot allow you to make end-of-life decisions, for example, because your child is a legal adult. Your child should have a power of attorney. Again, it eliminates the courts, eliminates any confusion. The other thing, when I said the law will take care of you, the law will actually make decisions for you as well. So there's a legal, the statutes actually name people in priority to serve. So in the state of Arizona, the first person to serve for you to be appointed by the court as a guardian and conservator would be your spouse. After that, it would be your parents. After that, it would be your siblings. Then it would be any and all other blood relatives. So if you don't want your spouse to be appointed or have the duties and obligations to serve for you, you can name whoever you'd like under a power of attorney. This comes in handy, and it also can be a downfall if, for example, your spouse is starting to fade, maybe having a little dementia, Alzheimer's. You might not want the doctors contacting that spouse to make any end-of-life decisions for you if that spouse is unable to make them even for themselves. Also, Arizona no longer recognizes common law marriages. So as those are people who are cohabitating for a certain period of years, and they're considered to have the same rights as spouses. So anyone who is cohabitating or has a best friend or somebody that they live with, you must have a power of attorney because that person has no legal standing to handle anything for you. So quite literally, your blood relatives could kick your significant other out of the hospital and demand that you're not allowed to see them. So if you have that power of attorney and you do name your significant other, then actually they have the legal authority to make all your decisions. And they might be the closest person to you and know exactly what you would like to have done in any sort of end of life decisions, paying your bills, filing your taxes, being able to even sell your home should they have to pay for your continued long-term care during your lifetime. Powers of attorney are extremely expansive. They're extremely powerful. But at the same token, they're absolutely necessary. It's probably the only estate planning document that I tell everybody that you must have. Because during lifetime, we all know we're going to die, but none of us actually plan on becoming incapacitated. And incapacity can be a much longer, drawn out, frustrating, and trying process than actual passing away or dying. So the lifetime documents, I believe, are the most important. Powers of attorney, naming who you like, who you trust to handle your medical, personal, mental health, behavioral health decisions during your lifetime, and then financial power of attorney. So over your finances, your bank accounts, your property, your home, filing your income taxes. So definitely get those done. And then I'm seeing a couple things in the chat. Do you want to?
Yeah, so I actually have several questions, and I want to go back for a minute because we have several people that asked about, the concern about if they're starting to see signs of dementia in their loved one, when can they do it? How can they do it if that's happening? And I wanted to know if you could, tied to that, explain legally what incapacity means. And then I have more, but that's a good start.
Okay, so I can only speak for the state of Arizona. Arizona, along with Florida, we have some of the most comprehensive probate and trust codes in the nation. Obviously, we're large retirement states, and so we have seen essentially every single fight and every single weird estate planning, probate, trust situation known to mankind. So Arizona has defined legal capacity. So legal capacity, there's two different standards. One is for your will, like a testamentary disposition. So for you to sign a will, you need to know essentially the objects of your bounty is the legal term. So that means your legal heirs, your children, who is blood related to you that would inherit just by blood. You also need to know the general nature and description of your property that you're devising under a will. So you need to know, you have a home, a bank account, how approximate values. And then you also need to know the nature and intention of your act. You need to understand that you are signing a last will and testament. When is a last will and testament valid? So Arizona, the standard of capacity, legal capacity to sign a will in the state of Arizona is actually much higher than the legal capacity required to sign a power of attorney. So powers of attorney in the state of Arizona, it's a lower level of capacity. The person just needs to know the person they're naming, so who they are naming to serve, and they need to know the general nature of the powers they are granting to that person. That's it. So, if you have a spouse who's been diagnosed with dementia, even diagnosed with Alzheimer's, if they know who they want to serve for them and they know what a power of attorney is, what does that mean? So I sign a power of attorney, but that means if I can't speak to my doctors, this person can. That means if I can't sign a check, this person can. They have legal capacity to sign a power of attorney. There are many situations where clients wait, not to the very last minute, but close. And we meet with the person that needs the power of attorney. We make a legal determination as to whether or not they completely understand and comprehend what they are signing and doing. And we do have them sign a power of attorney and thereby avoid a guardianship and conservatorship for that spouse. So it's never too late. You don't need two doctors' letters saying that they have legal capacity. You don't need to take them to a neuropsych evaluation. They don't need to go see a neurologist. They just need to have a very general and basic, they just need to meet the general and basic legal requirements of capacity to sign. Obviously, the sooner the better, but it's a lot lower standard than it is for wills.
And capacity, meaning if somebody needs to activate that power of attorney, it could be a temporary thing. Doesn't mean that somebody's like in a coma and they're terminal, or they're in that vegetative state where that living will and that would be activated. But like it could be, go in for surgery and the anesthesia, they're having a hard time coming out of anesthesia, might be experiencing some delirium. So it can be a short-term situation where that power of attorney could then be activated, correct?
Right. Absolutely. So, so this is actually a really good question. So Arizona has two different types of powers of attorney. You have a continuing power, which means that power of attorney and the powers granted underneath that legal document are valid as of the day you sign it. So in other words, it's continuing power. For my power of attorney, for example, is continuing. I guess my husband could take my original power of attorney to my doctor's office and get copies of all my medical records, but I trust him. So also in that, really quick, is that most doctors will not talk to my husband if they could talk to me. You know, my husband and I, all bank accounts are joint, so there's really no secrets there. So you have a continuing power where when you sign that document, all those powers are granted to that person at that moment. Then you also have what is called a contingent power of attorney, or in some states, they call it a springing power. Saying that this power of attorney and all legal powers granted here under are only valid upon my legal incapacity. So in other words, legal incapacity at that point, usually defined as two doctors with written statements saying that you do not have legal capacity to handle your medical and or financial affairs. So you can have a power of attorney where you say, okay, I trust my daughter to handle all of these things for me during my lifetime. However, she has no power until a doctor says that I don't have legal capacity. So, you know, once I'm blitzed or I'm cuckoo, then she can take over. You can have that in the document as well. So a contingent, all the powers granted contingent upon your incapacity, or a continuing power where it's valid today. So that's essentially what you're getting at.
And I have had a couple of questions sort of like around the same idea. So you mentioned earlier, at least in your state of Arizona, that you can have an and or listed power of attorney. So if you have a situation where you have like your primary and then like your spouse and then your sister or your brother and or, is there an issue or can there be an issue that they might disagree with the plans, and then what can be done in those circumstances? And that, not to give you too much question, but there is a question that came in about, you know, if you have stepchildren and they want to do something, can they come in and take over and
Oh, okay.
what's the parameters in a circumstance like this?
Okay, so first let's start with, so you name a primary person or you name a whole bunch of people. If you name them in the and, that means that, for example, Joe and Jane have the power. That means Joe and Jane have to be present. Joe and Jane have to make the decision at the same time. Joe and Jane have to sign every check together. So Arizona, like I said, allows for the or. So if you say Joe or Jane, it's either one. So if Joe is at the hospital, Joe can talk to the doctor and the doctor can completely follow Joe's instruction. So the difference between the and the or. So when you have people in the or in the and, so in other words, you have co-agents or people serving at the same time and they do not agree. This happens quite rarely, but again, the law has created a solution for you. And so let's say Joe says, pull the plug, and Jane says, absolutely not. Well, they go to court. They go to a judge and they make their arguments. They're on equal footing and they make their arguments as to, yes, pull the plug, no, don't pull the plug. And the judge would have the final say. That is where powers of attorney, like I said, are so incredibly comprehensive and expansive and so powerful. What you're granting these people the rights to do, the legal right to do for you during your lifetime, that you truly need to name people that you really trust. Sometimes people will name an odd number of people because then it's kind of majority rules. But I've had a couple clients saying, well, I want my son and daughter to be named, but they don't get along and they haven't spoken to each other in 10 years. Well, that's a recipe for disaster. I mean, you know where that's going to go. Talking about stepchildren or other family members. If you have a power of attorney and you have named someone, it could be your best friend, your next door neighbor, and the family members come in and say, I don't want this happening, I'm going to take over. That family member has no legal right to do that. It's only the named agent under the power of attorney. We've actually had that situation where a client of ours named their significant other because they did not want their children serving under any circumstance. So of course, the partner went into the hospital. The kids got all upset because they didn't know. And they, of course, came into town. Haven't seen mom in how many years, but came into town. They're going to take over. And they wanted to kick the significant other out of the picture. Significant other said, sorry, I have a power of attorney. Significant other actually went to the court, got restraining orders against the kids, and the kids were not allowed to see mom. So that is how powerful an agent under a power of attorney can be. And again, here's the good thing about doing it during your lifetime and not getting the court involved with the guardianship and conservatorship is by and through the power of attorney, you have the control. You have the choice. It is your decision who you name. It does not matter what your kids agree with. It doesn't matter what your family members agree with. That is who you trust. If you leave it up to a court and you don't have a power of attorney, the court will appoint people based on their blood and familial relationship to you, whether or not you've spoken to them for years, whether or not they hate you, whether or not, put it this way, whether or not they're an addict, they have substance abuse problems, they have mental health problems. The court will first contact those persons legally entitled and in the line of succession to serve for you. So it can be a very scary thing when it comes to appointments of guardians and conservators by and through the court. And again, that's why we tell all of our clients, you control it, you do this document during your lifetime, and everybody just kind of has to deal with it, for better or for worse.
Right. And I have two more questions on power of attorney, and then I think you've got a lot of other things that you want to cover. So one of them is for those people who might live in more than one state. So they might have a winter place and then a summer place. Do they need to have two different powers of attorney if they live part-time in another state?
No. So we get this a lot. Obviously, Arizona, we have a lot of snowbird clients. You should have your primary legal documents, whether that be power of attorney, living will, last will and testament, trust, drawn up in the state of your legal residency. So where do you file your income taxes? Where is your car registered? Where are you registered to vote? That would be your primary residence and your primary residence state. So if you have, for example, I have a client, their primary residence is Minnesota. Their Minnesota legal documents are completely valid out here. Completely valid. Powers of attorney. Arizona has a very specific statute actually in our probate and trust code, which says that any legal document drawn up in another jurisdiction that was validly executed in that jurisdiction. So even if it doesn't comply with Arizona's signature, notary, witness requirements, if it was validly drawn up in that state, it is completely valid here. What people run into is it takes an Arizona doctor longer to read a Minnesota power of attorney. It takes the Arizona hospital, they have to send it to their legal department because it's a Minnesota power of attorney. Will they eventually come back and say, yes, it's legal? Absolutely. How long will that take? Who knows? The one thing you don't want to run into, and this is where I get a lot of people who do the online forms, the free online forms. For example, the state of Arizona, our Attorney General's office has fill in the blank healthcare and mental health powers of attorney. And a lot of people come out here and they fill it out. And what they do is, so let's take my client from Minnesota. So she has all documents from Minnesota, powers of attorney, everything. But she comes out here and she fills in the fill in the blank forms and names her neighbor for healthcare. Well, if the power of attorney that's signed here in Arizona for healthcare is dated after, signed and dated after her Minnesota document, it technically revoked the Minnesota document. So you don't want to have two competing legal documents. So let's say the Arizona fill in the blank form, you name Joe, but in Minnesota and for everything else you have, you name Jane. Well, if Joe's power of attorney was signed after Jane's, Jane has no legal authority. So you can get into that, and that can be quite a mess. So we generally tell people, if you do want to have powers of attorney in each state that you snowbird in, make sure you name the same people, because if you don't, there could be a contest in one state or the other. But do you have to have estate planning documents in each state in which you have a residence or a vacation home? Absolutely not. The state of your legal residence and those legal documents are completely valid. So, and another thing I'll just touch on quickly in case anyone had a question on this, the age of the document. So I have people come in, they say, oh, my power of attorney is 10 years old. It can't be valid. I have to update it. What I was just talking about also, moved here from Minnesota 2 years ago. We're now permanent residents here. All of my Minnesota documents are void. No, does not matter the age of the document, does not matter where it was drawn up. They are your valid legal documents. So, you know, you don't have to update your power of attorney every 2 years, unless there's specific verbiage in the power of attorney document itself that it has an expiration date. I will tell you, 90% of them do not. Unless there is a specific expiration date of the legal powers granted under that power of attorney, there's no expiration date. They're good in perpetuity. So you don't have to worry about doing it every 5 years or anything else.
Well, that's good, because that was my next question for you related to the power of attorney.
Okay, good. Yeah, the date.
Yeah.
So, so we'll move on. So we did the, I think we understand the powers of attorney and how important those are. Really quick, we'll touch on, we call these kind of like the companion documents. With powers of attorney, you have, of course, the living wills, and then you have the DNRs, the do not resuscitates. The big difference between a living will and a DNR is a living will is your declaration to the world of your intent, your wishes, that you do not want to be kept alive by machines. So if two doctors say that you're in a persistent vegetative state, irreversible coma, you're telling your agent under your healthcare power of attorney that you want to be able to die naturally. So don't keep me on the ventilator, don't keep me on the bypass machine. So the agent under your power of attorney has a fiduciary duty to follow your instructions. So a lot of people have the living will to simply kind of reiterate their wish not to be artificially kept alive by machines, and also to kind of browbeat the agent, like prey on their conscience that it's not their decision, it's truly your decision, and you have said that you don't want to be kept alive by machines. So in the state of Arizona, we also have a do not resuscitate, a DNR. They're on pretty bright orange pieces of paper. Your doctor, your primary care doctor, actually has to sign it. And a do not resuscitate, the big difference between a DNR and a living will is a DNR is a mandatory document. So it is not just your declaration to the world, your statement of intent, what you hope to have happen, what you wish to have happen. A DNR is mandatory, and it says, do not resuscitate me. I had a horrible case, a sad case, where the husband and wife living together, husband had a lot of heart issues, heart disease, and he had a DNR. They were sitting in their living room one evening. Husband makes a noise, collapses to the floor. Wife calls 911, and EMTs show up. They knew of his DNR. He had a DNR bracelet, and the DNR was also on the refrigerator. And his wife, as agent under his medical healthcare power of attorney, said, zap him, do CPR, let's do this. And the EMTs would not follow her instruction. So since he had the do not resuscitate order, that superseded any instruction that she gave. It was very hard for her. I do know that the EMTs forcibly removed her from him because she was trying to give CPR. And the EMTs by law had to follow his instruction. So a do not resuscitate is a very, very powerful document, and it actually removes any legal authority or any decision making or any wish of the agent named under your power of attorney. The only time we recommend that someone has a DNR is terminal illness. You'd be resuscitated to what quality of life? And other clients who are just very adamant that they do not want any sort of resuscitation. To drive this matter home just a little bit more, if you were to choke on a steak bone and EMT showed up and you did not have a pulse and were not breathing, they would not resuscitate you if you had a DNR. If you have a living will, they will resuscitate you. They'll bring you back. And I find that most people want to be resuscitated. I mean, they want to, if there's a chance, they want to take the chance. But they just don't want to be artificially kept alive. So if you are in that situation, you are resuscitated, you are on a ventilator, you are on a bypass machine, you have no brain activity. If they did unplug the machines, you would die naturally. That is where the living will comes in. But a DNR is mandatory, and it takes all power away from your named agents under the powers of attorney. So that's very important to keep in mind. I will tell you that I did get into a, verbal altercation. I got a little snippy with the doctor at a hospital for a client of mine. This one doctor kind of made it a habit to hand out DNRs to any patient of his that was over the age of 80. Take that as you will. And so I was standing there visiting her in the hospital, and I noticed that she had a DNR bracelet on. And I said to her, I said, well, Helen, I said, you don't have a DNR. We had done all of her estate planning documents for 10 plus years. And I knew she didn't have a DNR. And she's like, I don't know. I just was admitted here and they just slapped bracelets on me. You know, she had the do not fall. She had the allergy to penicillin bracelet. And she also had this bright orange one. And so a nurse came in and I said, I need you to cut off the DNR bracelet because she doesn't have a DNR. The nurse said, absolutely not. I'll go get the doctor. And so they did. And the doctor said, well, that's only put on her because there's a DNR in her medical file. And so I said to her, I said, well, Helen, when did you sign a DNR? And she's like, I don't know. And they just handed me a whole bunch of forms when I was admitted here and I signed them. And lo and behold, right there in her medical file was a DNR. She had no idea what she had signed. She thought she was signing a Medicare release and, those kind of things. So I said, well, you need to rip that out of her medical records. And the doctor said, I'm not going to do that. I looked right at Helen. I said, Helen, do you want to have a do not resuscitate order in your medical record? She said, absolutely not. I said, if you crash, do you want to be resuscitated? She said, absolutely. And I looked right at the doctor and I ripped it out of her file. So watch out for that. They are extremely powerful. Sometimes they are just a part of a hospital admission packet. And if the person does not want one, you have to make it loud and clear to any hospital that might have known about it or has a copy, your primary care doctor, that you do not want a DNR. You do want to be resuscitated, but you have a living will, which states you don't want to be artificially kept alive. But that really drives home how powerful those documents are. So.
And if that happens, like, I know you were able in that circumstance to intervene, but, people are signing documents unbeknownst to them. Can they revoke that? Like, are there any special steps that they have to go through? Can the family help them and advocate for that? Or are they going to say, no, she signed it or he signed it and that's it? I mean, what are
kind of like Helen's case? To revoke it, you just simply rip it up. There's no like magic revocation form or anything else. Destroy it, shred it, burn it. Doesn't matter. Crumple it up, throw it in the waste can. Get rid of any and all other notifications of a DNR. Sometimes they have like a little card that you put in your wallet. Sometimes they have a little bracelet that you wear. And most importantly, make sure that your primary care doctor does not have a copy of a DNR. Make sure any hospital that you went to does not have a DNR. And be sure to let them know if ever you're admitted saying, I do not have a do not resuscitate order and I do not want one. That's how you actually revoke those and make it loud and clear that you do not want that. Also, the family members, like you were asking, they would do the same thing. Just make sure that everybody is definitely on notice that this person wants to be resuscitated. So,
well, and someone made a really good point because a lot of the signing is now digital. And so they may not even know, like you go through it really quick and you just, tap and sign, and unless you get that bracelet put on there, it could have been from a previous admission. Like, so you would have to then make them go back and review and find that
Right.
And then how do you remove it if it's digital? Like, you can't rip it up if it's digital.
Correct. And so you would actually have to be more proactive on that and make sure that any and all digital copies are also destroyed or revoked or removed from your medical records. And I mean, I'm an attorney, but I mean, I don't read those end user agreements. You know, you just scroll down with your little mouse and you hit I agree, so you can access stuff. I'm hoping that that never happens with any sort of medical provider. With regard to something as serious as a DNR. I know right now they're not a packet of, click, 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 click. But I will say that a DNR is still legally valid even if your doctor doesn't sign it in some states. So watch out for that. I hope it never becomes a part of just click here, next, e-sign, initial here, date. But if you are fearful that your loved one or somebody you were named, you're named for to serve under the healthcare power of attorney who has made their preference known that they do not want a DNR, it would truly behoove you to be very proactive on that and make sure the primary care doctor doesn't have a copy. Hospitals they've attended do not have a copy because, again, they are mandatory documents and they will be followed, notwithstanding what somebody standing right there yelling at them says. So just keep that one in mind for sure. And any other questions on this one, or do you want me to move on?
No,
Okay.
I know you've got so much more to cover, so I think we've really covered that one well. Thank you.
All right. So, so I was saying, so the lifetime documents, we have the powers of attorney, we have the living wills, we have the DNRs. Also, and trusts are a hybrid. They're effective both during your lifetime and after you pass. So we'll just stick to the basics in light of time. So, so lifetime documents, powers of attorney, living wills, DNRs, after death documents, last wills and testaments, beneficiary deeds, and non-probate transfer designations. So it would be interesting if we took a poll and asked people, how many of you have heard or believe that the only way to avoid probate is to have a trust? There are free dinner and lunch seminars out here in Green Valley, very popular because large retirement community, that all they do is sell and push trusts. Their biggest spiel, the little cards, the little letters people get in the mail, is that the only way to avoid probate in the state of Arizona is to have a trust. That is 100%, 110% wrong, false, it's a lie, it's a scam. So don't think that. I get so many questions on that. I actually wrote like a public service announcement for the local newspaper here back in 2016, because I had clients of mine coming in saying, Phoebe, I have to have a trust. You said I didn't. I'm going to have a probate if I don't have a trust. And I actually asked the editor of our local newspaper if I could write like a public service announcement, kind of dispelling all of this misinformation that is put forth. So a last will and testament, and the word probate. So the word probate means the proving of a will. And of course, the only entity that can prove that a will is valid as a last will and testament is a probate court. So that's where probate comes from. And probate only applies to any and all assets in your name alone at date of death that do not have what are known as valid non-probate transfer designations. Put it another way, any and all assets in your name alone that are not held in joint name, do not have a named beneficiary, are not POD to someone, are not TOD to someone. So payable on death or transferable on death. So if all of your assets have named beneficiaries, so all of your assets are in your name alone throughout your lifetime, but if you die, that asset actually tells me where it goes. So we have a bank account in Jane's name alone, but it says if POD, payable on death, this account shall go to Joe. That account is not subject to probate because that account is not in your name alone with me not knowing where it goes after you pass away. So only those assets that are in your name alone that I don't know where they go, that's when I need to go find your will. That's when I'm looking at probate. Okay, so if I find an asset that does not tell me where it goes, I need to find your will to find out where it goes. So that's that. Last wills and testaments, obviously you say who gets what and who's in charge. Some states allow them to be much more comprehensive, talking about, do you prefer funeral, funeral, no funeral, cremation, earth burial. Arizona also allows you to dispose of your tangible personal property by and through a will by a separate written list that you create on your own. So for example, people say, well, how can I name beneficiaries on the stuff in my house? Like who gets my sofa, who gets my recliner, who gets my Tupperware? You can actually devise a list saying, all my Tupperware to Jane and all my jewelry to Janie and all my tools to Jim. So that's how you can take care of tangible personal property. I will say that some of the biggest will contests we've ever seen or litigation after someone has passed away is over your junk. I mean, it's quite literally junk when you look at the actual value of it. But there's no actual price you can put on sentimental value. We had two sisters sue each other for over 2 years in Pima County over a little Hummel figurine that was chipped, cracked, faded. It was grandma's, and this sister stole grandma's necklace back in high school, and this one never got anything. And I actually went on eBay and I found the same exact Hummel, except it was mint condition in the box, and it was $40. And I would say that between the two of them, they probably spent about $30,000 to $40,000 in attorney's fees in litigation over this little figurine. So, so that's always good to dispose of your tangible personal property. So wills, that's really what a will is. So I have clients who say, okay, so I have everything in joint name with my spouse. And after that, we have the kids named as beneficiaries on everything we have. So why do I need a will? Well, you need a will for the what if assets. So what if you have an asset in your name alone at date of death that you didn't know of? For example, you win the lottery and you drop dead. The Powerball check for $40 million comes made payable to you, not payable on death to your spouse, not beneficiary to your kids, not, let's say you have a charity named as beneficiary on everything you have, not payable on death to the charity. It comes to you. So now I have this check that's made payable to you and doesn't have a named beneficiary, not in joint name. And so now I need to find your will. So there's a probate. Some people, I have clients that are pretty astute and they say, well, I don't play the lottery. And I said, okay, fine. So wrongful death, medical malpractice lawsuits. In the state of Arizona, a wrongful death lawsuit has to be made payable to the person who was injured. Well, the person's dead. So you get in a car accident, you're killed by an Anheuser-Busch truck, and Anheuser-Busch goes to settle and writes a check for $100,000, but they're writing it to you. So where does it go? I need to find your will. There will be a probate. So sometimes probates are unavoidable. That Powerball check, wrongful death lawsuit check, you can't control that. You didn't even know you had it. So it is always good to have a will to control those kind of situations. But how do you avoid probate? Take care of everything you know of and everything you can control during your lifetime. So all bank accounts, financial accounts, IRAs, life insurance, everything, name beneficiaries. And always take it a step further. Everybody names a primary beneficiary. So on my IRA, I name my husband, boom, I'm done. Well, if my husband and I are killed in the same car accident, he didn't survive me. So in any sort of beneficiary designation, through the financial institution that holds the account, always see if you are also allowed to name a contingent beneficiary. So I name my husband as primary, and then I name a charity as contingent. So if my husband and I are killed in the same car accident, the charity actually gets that asset and is not subject to probate. So really quick, I know we're running low on time. There are certain assets that people don't know how to name a beneficiary on. Number one is real property. So the state of Arizona actually allows for you to do what is called a beneficiary deed. You're actually naming beneficiaries on your home. The coolest thing about a beneficiary deed is, number one, it avoids probate should you pass away and still own the home. But number two, the named beneficiaries own nothing during your lifetime. So if you need to sell the home, you want to paint it purple, you want to rent it out, you want to do a reverse mortgage, it's still your home. So the beneficiary deed is only effective if you pass away and you still own the property. So the beneficiary deeds are great. I did a little research that there's 29 states in total, 29 states plus the District of Columbia, DC, that recognize beneficiary deeds, but some states call them a TOD, TODD, so a transfer on death deed. So this is how you avoid probate on your real property. You don't need to add your kids to the deed. You don't need to add them as joint tenants with right of survivorship. Actually, I advise you not to, because if the kid gets sued, guess what? They own half your house and you might lose your house. That did happen to a client of ours here in Green Valley. But the beneficiary deed or the transfer on death deed is a perfect way to avoid a probate in any and all states that you own real property. So probate, as it applies to real property, has to be, your estate has to be probated in the county in which the real property sits. So if you own a piece of property out here in Arizona, and then you also own one, let's say in Wisconsin, you can do a beneficiary deed on both the Arizona property and the Wisconsin real property and avoid a probate in either state. So it's a great, great legal way to avoid probate on your real property. And then also with non-probate transfer designations, you know, talk to your broker, talk to your bank. You know, may I name a beneficiary? Can I make this account transfer on death, TOD, or payable on death, POD? Arizona has gone so far as to our MVD, or DMV as they call them in other states, actually has a beneficiary designation form for your vehicle. So your vehicle, your golf cart, a mobile home, a boat, anything that's registered through our motor vehicle division, you can do a beneficiary designation form for that as well. Beneficiary designations obviously avoid probate. They also avoid contest. So you have two kids that don't get along, and one kid you haven't spoken to for years and might have a substance abuse problem. So you want to leave everything to the other child. Well, non-probate transfer designations, although yes, I mean, they can be contested, they're actually outside the purview of the probate court. So if you make an account payable on death to Joe, the other child, let's call him Jim. Jim knows nothing about it. Jim cannot request information about that account. Jim cannot go into the bank and demand to know who the named beneficiary was. Jim cannot stop the distribution of that account to Joe because Joe was the named beneficiary. So not only do you avoid the courts, you also avoid any sort of disclosure as to the identity of the named beneficiary, and you also avoid any sort of contest or any sort of attempt to stop the distribution of that account. So that's really, between beneficiary deeds, POD, TOD, beneficiaries, there's really that's how you avoid probate. That's how you make it easy for people. So you want to make it easy for your successors during your lifetime, obviously powers of attorney, living wills, DNRs if you want one. So you want to make it easy during your lifetime for somebody to serve for you by having your powers of attorney, living wills. And then you also want to make it easy for them after you're gone by having beneficiaries named on everything, making sure you make that list to dispose of your tangible personal property, having a beneficiary deed, and making sure that everything that you have has a named beneficiary. So no lottery check, no wrongful death, no medical malpractice case. There's no probate. Everything goes out via non-probate transfers, and that's it. And that's all you can really do, is try to make it as easy as possible for those people you're naming to serve, or for those people you're naming to inherit things from you. The only thing you can do is to make it as easy as possible for the things you know of and the things you can control. The only time I see anyone get upset having to open a probate or a guardianship and conservatorship is when a family member, mom, dad, anyone could have signed a power of attorney and failed to do so, or could have named beneficiaries on everything and they chose not to. That's the only time someone gets upset on having to go before the court to have the legal powers to take care of things for you. If you have beneficiaries on everything, but then the lottery check or the wrongful death lawsuit check, Nobody gets upset about that because you couldn't control that. It was also something you didn't even know you had. So yes, there will have to be a probate, but I always consider it's found money. It's free money. It's money you didn't even get to enjoy, money you didn't even know you had. So the only thing you can really do is try to make it as easy as possible for those that you're leaving behind. And really, other than that, because I don't think we have time to get into trust and all that fun stuff, but just the
and
basics.
I know there was a couple of questions about asset protection, Medicaid, and like if one of the spouse needs to be on Medicaid, how that impacts the community spouse if they have to be placed.
Right.
Or they're trying to get like a home and community-based waiver type program, which is funded through Medicaid. Like, you know, in the 4 or 5 minutes we have left, I'm not sure you can cover that, but
so I'll touch quickly on it. I'll describe just Arizona because I don't want to get into hot water with any other states. So Arizona, we have so it's my understanding that each state has its own form of Medicaid. Arizona, ours is called Access. So it's Arizona Healthcare Cost Containment System. And underneath that is Altex, which is Arizona Long-Term Care System. So Arizona being a community property state, the one thing that most people don't understand is you do not have to spend down all of your community assets to the $2,000, as the total asset value minimum level before you qualify. You only have to spend down the community partners 1/2. The logic behind that is the state does not want to bankrupt both. So if only one is going to need it, you only need to spend down that partner's 1/2 of all community assets. There's also exempt assets. So a house can be exempt if the other spouse is going to continue to stay in the house. Like the vehicle, that's exempt. Certain personal property is exempt. Certain separate property, if you had a 401k or an IRA from an employer prior to the marriage, that's separate property. So again, the state of Arizona doesn't want to bankrupt both of you because then you both would be on the state's, not payroll, dole out. So that's the first thing to think of. The other thing is Arizona does allow you to, do certain estate planning methods, trusts to shield certain assets. And then if you actually have income over the amount that Access says that you have to have a minimum amount of income in order to qualify. Arizona recognizes what is called a Miller income cap trust. So you actually have the overage of your monthly income go into this trust and you can still qualify for Arizona's state Medicaid program. Medicaid planning is something, just to kind of wrap up and do like a short conclusion or synopsis. So Medicaid planning, if you believe that your spouse is or may be in need of long-term care for any time in the future, let's say it's 2 years from now, 3 years from now, the sooner the better of going to talk to an estate planning attorney or a Medicare planner or Medicaid planner, the sooner the better. I have counseled clients and they say, hey, it might not be 3-4 years before my spouse might need it. Come talk to me now. Because now I can tell you what you need to do, what you need to start documenting. What if they have a drastic change in health or need? What if they don't? What if they're fine? It's better to talk now than try to do the planning once you need to place someone. Because as we all know, long-term care, depending on whether it's just assisted living or a skilled nursing facility, can range anywhere from $3,500 to $10,000 a month. So how quickly your assets can diminish if you wait to the last minute. If you think that your spouse might be in need, go talk to someone. It doesn't hurt to talk to anyone, and especially to your state particulars of what they do allow you to protect by and through trusts, and what they do count all the time, and what assets are straight up exempt. So you don't have to fear, and at least in the state of Arizona, you don't have to fear losing your home just because one spouse has to go into long-term care. So.
Awesome. Well, okay, we didn't get to cover everything, so we're already getting comments that you're going to need to come back and cover the trusts, because there's that could be an entire topic in and of itself. And I know that we didn't really, and you mentioned it, but I didn't really get to delve into, like, if you wanted to gift somebody, like a nonprofit like PMD Alliance, and how that could be a part of your planning as well. And, you know, those are important conversations because, you know, those are things that might be very important or very meaningful for people. So I may have to invite you to come back so that we can.
Well, I was actually gonna suggest that when you brought up the whole Medicaid and trust planning, but I didn't want to, you know, jump the gun. I didn't want to be presumptuous.
Well, you're not being
But I would love to come back. Absolutely.
Right. I think that will be, I'll follow up with you on that. But yes, and so I really want to thank you because this has just been a wealth of information that all of us need to know. And so I've done my estate plan, but I already told Phoebe I need to go back and there's some things that I want to change. So, you know, I really appreciate you delving into this. We definitely are going to get you back on to delve into it a little bit more. And for those of you who are watching today, you probably have heard that this is our 6th birthday at PMD Alliance. And that was kind of why I brought up that legacy, because you can gift through our legacy circle, and Maureen Simmons is our VP of advancement, and she can be helpful if you have an interest in that. You can also just give a small gift to us as a birthday gift, because we're still matching and we're about 75% of goal. So if you guys have a heart for, you know, what we're doing and we've touched you in some way, this is a great way of giving back. And allows us to continue to have programs like this and wonderful speakers like Phoebe. And so Phoebe, I'm going to do with you as we do all of our wonderful speakers, and that is to give you the wave of gratitude from all of our listeners today, because you are fantastic and you are a wealth of knowledge. I don't know how you keep all these details, but you know your stuff inside out. So that is great. So if you guys need an attorney in that area, she's one. If you are in another state, you have questions, because we couldn't get into some of them specifically, I really encourage you to look for an estate planning attorney, elder law attorney that specializes in this. The difference between that is just that is their area of expertise, what they focus on. So please, you know, take care of things before it becomes an issue. Phoebe, thank you so much. This is a great
Thank you guys so very much.
Thank you everybody for joining us today. Have a wonderful, wonderful weekend.
All right. Thank you. Bye-bye.
Bye-bye.